Good morning. This is Victoria Beal with the Ohio LTAP Center, and we are so pleased to be partnering with the Supported Services section of the Division of Opportunity, Diversity, Inclusion at the Ohio Department of Transportation to provide this morning a training on risk management for construction contracts. And we have Patrick Espinosa, who will be your presenter this morning. Before I turn things over to Patrick, I have just a few housekeeping items. First off, in the Go To Webinar panel box, there is a section that says handouts, and there are 5 handouts there for you. Please download those at your convenience during the webinar so you have the handouts. They have been provided by Attorney Espinosa, and we want to make certain that you have those as a part of your learning experience. The webinar itself, the slide deck is in there for both today and tomorrow. If you have not registered for tomorrow yet, please make sure you do so because that's part 2 of this course. We also have some poll questions we'll be asking you that'll be coming up during the presentation. But most importantly, in that GoToWebinar panel, there is a questions box, and that's where we would ask that you enter any questions that you have during the presentation this morning, and I'll be reading those off to our presenter during the presentation. If we do get an overwhelming number of questions, which I certainly hope we do, because we want this to be a great learning experience for you, we will follow up afterwards with a Q&A document. We want to make certain that we have enough time to get through the presentation this morning. And last but not least, we want you to know that at the end of the webinar, and I'll remind you again when we get there, we have a survey that we'd like for you to complete. Last week, there was one day when the survey didn't function correctly during the estimating training, but one of the 2 days it did, and we got great feedback. And we want to make sure, so long as the box pops up, that you're able to take that survey today. So that's all I have. Patrick, are you ready?
I'm ready to go. Thank you, Victoria. Good morning, everybody. My name is Patrick Espinosa, and I'm here to discuss risk management when it comes to contracts. Now, I'll let you know, this is the first time I've done a webinar. I generally do seminars several times a year. I've been a teacher for many years. I'm used to having faces in front of me, so just bear with me if I'm getting used to this. Couple of things for the handouts. We're only going to be going over one handout today. That's going to be the sample operating agreement. And for those of you that haven't signed up for tomorrow, today we're going to go over general contracts law and things you should be aware of. Tomorrow it's going to be more of a dive down into construction law. So I am a senior partner at Lorenzen Law here in Cleveland, Ohio. I've lived all across the world, in South America, China. My family is Colombian. I hold a law degree and an MBA from the University of Miami, and I started out my career as a NFL agent. So I guided college players and athletes through professional sports and got a lot of experience with some high money contracts. And I do business consulting and litigation with entertainment groups and other groups in Florida, Texas, here in Ohio. And I practice in state and federal courts across the country on many different kinds of cases. Now, I hope to share with you today and tomorrow some of the legal issues that you'll be facing in your career in the construction industry. If you're familiar with some of the issues that I cover, good, you'll get a refresher. If not, no worries, that's why I'm here. I want to expose you to as many things that may be unknown so that you can look into them and research on your own. So there's a lot of information to cover today, so I'll begin by going over some complex issues. Or I'll be going over some complex issues throughout the presentation. So if you have any questions, please ask them so I can answer them right there. If you want me to clarify something that you don't understand, please let me know. If you need me to give an example, please let me know. There are no dumb questions. I'm here just to let you know about a lot of things you may not have thought about that may break business. Most missteps in business are caused by unknown unknowns. You'll hear me say that several times today. I'm going to hammer home several concepts over the next 2 days. One of the biggest ones is know your contracts, know your contracts, know your contracts. You have to understand your contracts. You have to understand every term. That's how you make your money, and that's where some of the missteps will be. It's also a way that you don't want to be taken advantage of if you don't understand a certain term. I also want you to keep in mind that you'll be learning, exploring, studying things related to construction, not just right now, but throughout your career. You can't just do the job. You need to become an expert in your trade if you want to succeed. It takes hard work and research and studying. All the issues that I want to highlight over the next 2 days, you should want to look into more. Familiarize yourself with the concepts and terms so that when you're confronted with an issue, you'll know what to do. The more you know, the less likely you'll learn the hard way. But keep in mind that everybody learns the hard way. We all mess up and get taken advantage of when we're first starting out. Ask any seasoned contractor or any expert in any field, and they'll tell you stories about how they learned the hard way. So we're going to be going over again, some unknown unknowns. I'm going to be explaining some terms and some concepts that I want you to be aware of. I'm going to introduce best practices. I'm going to highlight some common pitfalls and explain some of Ohio's laws that relate to construction. If you see the capital K in any of this presentation, it stands for contract. Now, before we get started, I'd like to go over a disclaimer. All the information that I'll be presenting to you today should not be construed as legal advice. Every contractual situation is different, every construction project is different, and direct legal advice is given on a case-to-case basis. What I'm here is just to explore the unknown unknowns and share some stories and some examples. So I'd like to begin by giving you some questions to think about, some construction incidents that happened in the past. September 2005, there's a major casino in Las Vegas. They were constructing a second tower that was going to house 2,000 guests. Now, they were 15 stories up of 43 that they had already built. And it came to light that several weeks earlier, a sand technician at a concrete factory fell asleep on his night shift, and some chemicals didn't go into the concrete batch. That concrete batch went out and was poured into what was then the 13th floor. Some tests were done a couple weeks later. Turns out the concrete wasn't strong enough to withstand the pressures of the stories above. So what happened? Who's liable? How much of the mistakes cost? How are the parties affected downstream? What do you do if you own the concrete company? What do you do if you're the prime or the general or one of the subs? What if you were contracted for something on the project that hadn't started yet? What would you do if you were the owner? Now, we'll discuss these at the end of the presentation if we have time, or if not tomorrow. Another situation in March 2008 in New York City, workers were attaching a steel collar to a 200-foot tall tower crane trying to secure it to the building. The safety regulations stated that there were supposed to be polyester strings to stabilize the tower. Now, it turns out that only half of those polyester strings were being used. They became overloaded. That collar dropped, dislodged 2 lower level collars, which caused the crane to topple. So again, what happened there? Who's liable? So we'll begin over today more business entity basics. We'll be jumping into that here shortly. Go over the sample operating agreement. Operating agreements are the rules by which people run their business, and it's important that you start out on the right foot. Even before you get into the construction part, you have to make sure that all your business is in line and you know what rules govern your business. We'll follow that with some basic points of contract law. We'll probably go over those very quickly. Talk about the main components of a construction contract. Tomorrow we'll be doing more with change orders, breaches, claims. We're going over some litigation issues as well if you've never been in litigation, which hopefully you never will. I just want to give you the basics of what a typical lawsuit looks like, or other alternate dispute resolutions look like. Like Victoria said, we'll also have some poll questions here throughout. And again, please ask me any questions that you have. And if not, we can submit them in writing and I'll answer them today and tomorrow. So without further ado, let's go to the first poll question. Victoria, if you could put poll question number 1 up.
All right, I'm putting it up right now.
Thank you. And just actually, no, sorry. I was telling the audience to actually start a company in Ohio. It's not too terribly difficult. To do the beginning filings with the government is all done online. It can be done in about 10 minutes, and it's not terribly expensive. It only costs $99 for an LLC. But that's the easy part. What is a little bit harder is writing down the rules that you're going to govern yourself and your partners by. We'll be going over that in just a second. Victoria, let me know as soon as people.
Yeah, they're voting right now. We're almost up to 80%, so I'm going to go ahead and close the poll out the second we get there. Okay, we're there. I'm going to share the results, and you have 30% who are solo owners, 19% have partners, and 51% work for someone.
Okay, so perfect.
I'm going to hide that.
Those Those solo practitioners, this is still good stuff to know, even though it's not going to affect you right now. If you're a solo practitioner, you make all the rules and you're not going to have any claims or issues with any partners, but you may have issues with partners in the future if you decide to team up. And this is what I want you to make sure you understand. Those of you who have partners, please pay attention. And those of you that work for other people, hopefully in the future, you'll find yourself in a position to open up your own company and hopefully make a lot of money. Now, picking the right business organization, there's generally 3 types of business entities. There's partnerships, there are limited liability companies, LLCs, and corporations. You can also be a sole proprietor. Generally, partnerships and sole proprietorships, you want to stay away from these. The reason why you want to stay away from these is that you open yourself up to too much liability. The laws of incorporation in the Ohio State Code and codes across the United States limit liability to corporations and LLCs. So if you're a sole proprietor or if you're in a partnership and something goes wrong, say you breach a contract on a construction contract, God forbid someone gets hurt and sues you. If you're in a sole proprietorship or a partnership, all of your assets can be attached, meaning that if someone sues you, they can go after your house, they can go after your cars, they can go after your bank account. If you are in an LLC or a corporation, people can only sue you to the extent of the money that's in the business. So they can't come after your personal assets if you open up an LLC or a corporation. Now, the biggest difference between LLCs and corporations come down to 2 things: liability and taxation. Like I said, you have limited liability when you're in an LLC or corporation, and that's probably one of the most important things that you're going to have to think about when things go wrong. Benefits with the LLC, a little bit less complex. You're only taxed once. It's called a tax pass-through tax entity, so you're not double taxed. Benefits of a corporation or disadvantages of a corporation, you are double taxed. You're taxed on corporate income and you're taxed on dividends. Some of the benefits: it's easier to raise capital. You can issue bonds. You can sell parts of the company off if you need to buy construction equipment and whatnot. It's also easier to transfer your interest in a corporation as well. Think of it as buying and selling stocks. So articles of incorporation are what you file with the government, and that differs from the operating agreement. The operating agreement is the rules that you govern your company by. And Ohio specifically, the laws give us a lot of freedom when we negotiate the terms of an operating agreement. And this means you can negotiate with your partners or potential partners to make up any rules that you want, and Ohio State laws and courts will honor those agreements. Even silly stuff, you can say, it's mandatory to have a company meeting in Hawaii every August. That's the way you're going to govern stuff. You can keep people from transferring their share out of the company without offering it to you first. We'll go over that in just a second. But just remember that you're bound to the rules. An operating agreement is a contract, and you will be held to that contract. Always have a lawyer review an operating agreement before you sign. When you're negotiating, realize before and after, even if you're in a contract, that you may come to a situation where a partner has more money than you do, which means they're going to have more leverage on you when it comes to the business. So, you don't want to be forced into a bad deal. Always make sure that you have an attorney review it. So what should be in an operating agreement? Required information by law. You need to have your name of the company, company's address, your agent. Your agent's going to be the person that handles any claims. That's where claims and lawsuits goes to. And by law, they have to be in there. Main clauses, capital accounts. This is going to be one of the more confusing sections in an operating agreement. It's generally because you confuse the different the investment capital that the partners invest as opposed to the general books of the company. They're 2 totally separate things. And these are, freely negotiable. Members can set the rules on valuation. People can contribute money, equipment, even experience. Someone may have 30 years of experience but doesn't want to put too much money in, and these are things that you talk about in a capital account section when you're starting bigger corporations and LLCs. Fortunately for most people in practice, capital accounts are relatively simple. There's a simple amount, either $1 or $100. This happens more generally among smaller startups. It gets really complex in different kinds of companies, tech companies that need a lot of capital to be invested. That's where it gets pretty complicated. But for now, you shouldn't have to worry too much about it. And I just want to let you know that this section does exist. Again, remember saying know your contracts, know that it's, this section in operating agreement exists, and if you want to look into it more, please do so. The profits and losses distribution. This is where you decide how you're going to split up your money. Are you going to leave some in for future projects? Are you going to leave some in for capital investing? Or are you going to distribute all the money to all the partners? And you can set up all these parameters how you want. It also states where you set your fiscal year. Luis Cartagena next week is an expert on accounting. He can give you some tips on when you should want to set your fiscal year. Management and voting. This is probably the most important section. We'll be going over this in detail here shortly. Basically, these are the basic rules of the day-to-day business. You and your partners get to decide how decisions are made beforehand. Remember, this is when you're negotiating the operating agreement. Do you give unilateral decision to one of the decision makers, or do you split? And what kind of decisions need formal voting? There's a books and records section. It's just what it sounds like. It just states that your company has to maintain records. One thing I'll keep repeating is good record keeping is a best practice. You're going to want to record everything from the contracts you enter into, jobs, pricing. I know you heard Joe say that last week. I'm going to repeat it this week. Transfer of member interests. This is how you're going to want to be able to sell parts of your company. How do you value your company? Do you want to restrict voting? We'll go over that in detail here in just a second as well. And then dissolution and termination, the rules of how you wind up a company. We'll be switching over to the sample operating agreement handout here in just a second. But before we start, Victoria, could you put up poll number 2, please?
Launching it right now.
Thank you. And we'll be going over this section by section. And the reason why I want to take so much time to review this is because an operating agreement and dealing with partners are one of the 2 main causes for litigation when it comes to companies. Obviously, the other one being construction contracts. So these are the 2 areas: operating agreement and the way you deal with partners, and construction contracts. Those are where 95% of your litigation is going to come from. Pretty evenly split, I'd have to say. So I just want to make sure that I drill this into you, that I want you to make sure that you get started on the right foot. If you're starting on the right foot, it's going to save a lot of headache down the way. Now, I consult on operating agreements all the time, done so in the past for the last decade. Generally, we would spend about half a day going over all of this, even longer than that, making sure it's all right. So I got to squeeze this down to about 15 minutes. So I'll be going over a little quickly. So if you want to ask a question or have a question later, mark down real quick where you want. Victoria, were you saying you're done?
Sure. I was going to tell you that 74% of your audience has not created an operating agreement before, so this ought to be a great benefit.
Okay, perfect, awesome. I'm glad we're going over this then. That way you don't have to learn the hard way. You're going to look at this operating agreement and you're like, wow, I didn't know that existed. I didn't know that should be in there. I didn't know what to think about this. So I'm glad we're going to go over this in detail. Rule of thumb, generally, have a lawyer do an operating agreement or a consultant. The going rate can be anywhere between $1,000 and $10,000, with the average probably get a decent operating agreement for $2,000 or $3,000. You get it written for you, you get it explained to you. So it's not too expensive, and it's definitely something you're going to want to take care of before you get into business with someone. So let's go over this section by section so I can let you know what to be aware of. So this is just a sample. Everything's going to, your operating agreement for your company is going to be different, but they follow the same general structure. So all these main sections, main articles will be the same on operating agreements, throughout the country. Recitals kind of just say what the purpose is, that the members intend to be bound. Article 1 generally are what are mandated by the state laws. Have to say what kind of organization it is, whether it's a LLC, corporation. You want to have the name of the company, the term of the company. That's how many years it's going to be in business. Generally, that's perpetual, meaning that it exists in perpetuity forever. The purpose, you don't necessarily have to put that you're going to be in the construction industry. You're just going to say the company is going to be formed to engage in any lawful act or activity. That's all you need to do. You definitely have to have the location of your office and agent. Make sure that those are in there. Make sure you do have an agent. You generally don't want it to be yourself, just because of terms of service. If when lawsuits and claims start arising, you're going to want someone that knows how to deal with any defects in service, or just ways to protect yourself, or to make it harder for someone to sue you. If you put yourself, you may not recognize that someone's making a mistake in how they serve you. You know, and you can have certain ways of trying to avoid any litigation, or maybe have some extra time to fix something to avoid litigation. Now here's the section where you're going to have members. I put myself, Joe, and Luis, who you'll be hearing from next week. Very simply is 33 1/3. This is going to list out the percentage of your ownership, and it's going to tie into both the capital and profits and losses. Generally, you're going to make money on a percentage basis of how much you own of the company. Now, again, this is something that you can negotiate with your partners. If someone brings in more experience, or if someone brings in more money, that's going to be reflected in your interest. So, you know, it's going to be up to you individually on how to value someone's experience, whether they get more or less of the percentage. And if someone obviously brings in money, or a lot of money, that can influence these percentages. So, like I said, Ohio laws lets you freely negotiate. It's not a dollar for dollar thing. You know, you bring 100, I bring 100, and we're 50-50. You know, it doesn't work that way. So you're free to negotiate any terms you want, but understand those terms. Now, here is the capital account section. Like I said, it's a little confusing, and in practice, this is far more simple. Generally, you only have to deal with this when you start making bigger companies, when you start doing big projects, and you're the general contractor. You know, usually a little bit older, more experienced. You'll have seen several of these. But this generally states the rules of how your initial contributions are going to be, and whether you're going to keep your investment in the company. For now, if you're a small company, you don't really need to worry about this section too much. It's not too terribly important, but just want to let you know, as you get larger, this section will start to come into play when you have a lot larger dollar amounts, and when you're talking about buying millions of dollars worth of equipment, where that money is coming from, and how that money is going to be reflected in the operating agreement. You know, you'll need to get a little bit more intimate with this section of operating agreement. And of course, you know, any attorney, accountant, business consultant, you're going to want to check with them to make sure that the rules that you set in this section favor you. You don't want anybody to take advantage of you. Skip down to you know, your profits and losses. This is where you can set up your rules. Like I said before, you can set up your rules that say, you know, when you're done with a project or a contract, 100% of the money gets distributed to the owners in accordance to their interest amount, how much they own of the company. You can set the rules here that you're going to keep 50% in the company. You know, why would you want to keep 50% in the company? You're, you know, a little more or less. Keep money in the company to buy equipment. Can keep that money in the company to go through slow times, especially now. I know a lot of contracts have been affected by COVID-19. You want to make sure to keep money in the company to at least keep some parts of your business going, or at least, you know, to take some draws while you're in slow. So when you're an owner of a company, an LLC, you don't get a paycheck. You take what's called a draw. So you draw from the business account. Those rules would be set up in this section as well. You know, you don't have to take money out. You're not forced to. These are all rules that you need to talk about with your partners, whether you're going to leave money in, leave money out. So management. This is management and voting. is going to be one of the most important sections. This is going to lay out the day-to-day rules of your business and decision-making of your business. This is where you're going to list if you're going to put someone in charge. Is there going to be a CEO? Is there going to be a president? Who's that president going to be? What kind of authority do they have? What kind of day-to-day decision-making power do they have? What kind of major decision-making power do they have? Now that's listed out here, and it will be listed out. We'll go over here in a little bit in the exhibits, the employment contract. If you're going to hire someone as a CEO, if you're going to make a partner as CEO, what their pay is going to be. I'm going to toggle back and go over voting by the members. Again, if you own your own LLC, this isn't too important because you make 100% of the decisions. However, when you get into partnerships, day-to-day decisions usually don't matter too much, but some of these bigger decisions do. So what kind of decisions are major decisions? Admitting new members. Is there a partner wanting to join? Is he going to bring in $1 million? Can the president or one member make that decision, or is it going to be majority or supermajority or unanimous? Do you want everybody to vote for him? What if there's 5 members and 4 members like potential 6th member, but the 5th guy, they just don't get along? How do you resolve that situation? Do you want to be unanimous or just majority? Another couple of the big decisions that you have in companies: repayment of capital contributions, approval of the budget, amending the operating agreement. Do you want to change your rules? Sale or transfer of a substantial amount or all of your assets, approving mergers, acquisitions, purchasing capital. Construction equipment is expensive. Do you want to have a vote on what kind of equipment you want, how much should be spent? The voting procedures should be spelled out specifically. You're going to want to think about this beforehand, because if all of a sudden you have to make a decision and there's no rules of decision making, that's when fights break out. That's when people start having disagreements, which leads to litigation, which leads to people falling out. So if you actually discuss all this stuff before you get into business with someone, there's a lot better chance that you're not going to go through heartache of going through stuff the hard way and maybe losing a company and friends. It does happen all the time. People that get into business with their friends, family, there's some big repercussions. So it's definitely worth your time to think about this stuff before you get into business and not after. Because once you're locked in, you're locked in. And once you start making lots of money, the more money you make, the more problems you're going to have, the more litigation, the more heartache if you don't think about some of these decisions that you have to make beforehand. Also in this section, meetings. Can you do by teleconference, by video conference? Obviously, there are issues that you want to discuss. Our U.S. Congress has these issues. I know the stimulus bill that passed last week, it might have been derailed because one guy from Missouri said that he didn't want to do a voice vote. He said everybody had to present themselves. Obviously, we're trying to do social distancing, and some people were, not physically in the area. So these are things that are decided at the highest of levels. Proxies. Proxy is someone that you give authorization to vote for you. If you're not able to, whether they're incapacitated or just physically not available, you can actually have someone make decisions on your behalf. Books and records, exactly what it says it is. Just make sure you have a bank account. You're abiding by all the accounting laws. Transfer of member interest. This is another area that is worth taking a closer look at. So you get into business to make money with people, but what happens if you want to leave? What kind of rules do you want to set on the transfer of members' interest?
Joe? Patrick, I'm sorry.
Yes.
I'm sorry. I was looking at the wrong name here on the screen. We do have a question that came into the chat pod. It says, to apply for DBE certification, all businesses are required to have an operating agreement or bylaws, ? For a single person-owned entity, how complex should the operating agreement be?
It doesn't actually need to be too complex. The state of Ohio has laws that have been codified by our lawmakers that kind of give a default operating agreement on the rules of your business. They're written directly into law. They do follow this structure. So if you actually look at the law, they're going to look a lot like this. But it doesn't give you much flexibility. If you're by yourself, not too terribly complicated, just because you make 100% of the decisions. So you're not going to have disagreements with anybody. But it is important to realize what's in there and look at the stuff, so that if you do decide to get into business with someone, or if you do decide to, have multiple members, multiple partners in an LLC, that you know what's in this, so that you know where you can be flexible, you know what parts you can negotiate. But yeah, that is definitely a good question. There are default laws that this is based off of.
No other questions right now.
Sorry?
No other questions right now. Thank you.
Oh, okay, thank you. So transfer of members' interest. What if you want to leave? What if you're just tired of the construction industry, or you want to take a different path through your life? How easy is it to sell out your interest? Are you able to, can you freely sell it to someone else? Again, here is where you want to decide. What if you have partners that don't want to include anybody else, that would rather buy you out? There's clauses that can be put into this section of operating agreement called the right of first refusal, which means that if you want to sell, you have to sell to them first. And this is common in a lot of multiple member LLCs. Transfer of voting rights. What happens if you settle someone? Do the voting rights go along with it? God forbid something, you're incapacitated, you pass, your spouse, your family gets your interest by law. What happens to those voting rights? What if you have two partners that are very experienced in construction, and the person that gets your transfer has no clue about it? Should they be able to make decisions based on on construction contracts? Usually no. That's why you have to contemplate these things beforehand. When you do want to sell, accounting or valuation of the firm is really important. How do you value the firm? How much is it worth? How much have you put in? Is it just the money that's in the bank account, or is it equipment? Is it partially your experience? So this section is in a lot of operating agreements is pretty complex. The section on valuation alone, I've seen them 2-3 pages long, listing what accounting firm you're going to use, the certain date the valuation is going to be on, the process of how you do valuation. Some of them say each different member's got to pay for a valuation. It's got to do an audit by a major accounting firm to make sure that they get the value right when someone wants to sell. Really complex issues that involve other attorneys, accountants, so it can get complex. I just want to let you know that is something that exists out there. And here's also one of the biggest differences between LLCs and corporations. Corporations generally really easy to go back, really easy to get rid of your membership interest, just like it is if you were selling stocks. General provisions, these are the small print. This is at the end of every contract that you probably have never read. It's boring. You think it may not matter, but it actually does. This is called boilerplate language. I said if it's in virtually all contracts. If it's not in there, there might be something wrong. It should be in there. If it's not in there, it may show you that maybe a lawyer didn't write the contract. People try to write their own contracts all the time. You can write your own contract, but it's important to understand that there should be certain terms. And if this language is missing, there's probably some issues with the actual contract language itself, so it should raise a red flag. So a couple of ones that you want to watch for: fiduciary duty and conflicts of interest. Some people have multiple pokers in the fire. They have multiple projects at once, multiple companies. What if 2 of these companies are bidding on the same project? There's conflicts of interest there. This happens quite frequently in the business world, and it's usually resolved pretty easily. You just have to disclose to other partners that you do have interest in other companies that may be competing. Notices. Notices are a big part of the general provisions. They're going to list the address and how you're supposed to be notified of any claims. This is how, this is where you send lawsuits. This is where you send service. There are rules of how it's supposed to be served, whether it's supposed to be served by, certified mail. Does email do it? Especially with internal disputes with partners. you know, you have to send notice of certain claims in a certain way, and this part of the operating agreement handles that. Choice of law and choice of forum. Forum is the place where you actually have a lawsuit. So say there's 3 different partners, Akron, Toledo, and Dayton. You guys do contracts around the state. Now, the choice of law in an operating agreement or in any contract, these general provisions are parts of every contract, so you need to know them anyways. Choice of law matters. You know, say someone in Akron, say the operating agreement says the choice of law will be Summit County, Akron. Well, people that live in Akron, you know local lawyers. Those local lawyers know the judges. It's going to favor the person, the place where the lawsuit is brought. You know, if you're from Dayton or if you're from Toledo and you're forced to litigate in Summit County, you know, it's not going to favor you as much. There is a home court advantage when it comes to lawsuits. So you're going to have to keep that in mind. Severability clause. This means that if one of the clauses is void in the contract, it doesn't mean that all the rest of the contract's void. Indemnity clause, that just means indemnity insurance, means you're going to cover someone. You're not going to sue them, or you're going to pay if they do something wrong. And then entire agreement, merger clause. When it says entire agreement, it means that there is no verbal contracts. You'll find sometimes that people might make promises outside of the contract. They'll say, hey, I'll do this, do this. If that language isn't in the contract, then it doesn't matter. You know, you can't hold someone to those promises if it's not in writing. A couple of the attachments we'll go over very quickly. Looking at initial contributions, like I said before, in practice, it's generally easier. It's $1, it's $100. You see that myself, Joe, and Luis put $1 each in this example. Employment agreement. Use this, this as a sample. This lists out the duties and obligations explicitly for someone that's going to be a major decision maker. If you're going to elect someone to be able to make a lot of the high level calls, this is where you put all that information in. Going to NDAs, non-disclosure agreements. What are these? It means that if there's confidential information that you've used with partners to procure business, you're not going to spill these secrets. An NDA basically keeps you from using information or telling other people information that might give you an advantage. Very normal. There's also non-compete clauses. Say you have, there's 3 partners. One wants to get out in the zone and compete against the other 2. There's clauses that say that he can't do that. He's got to wait a certain amount of time or has to go after projects in a different area that are limited geographically. Non-circumvention, that means you're not going to cut someone out of a deal. Non-solicitation is you're not going to solicit, you're not going to leave a company or a multi-member LLC and then take all the employees with you. You can't do that. So these are general non-disclosure, non-compete, non-circumvention, non-solicitation forms. Spousal consent forms. This is for transfer of membership interest again. If something happens to you, your spouse or your transferee knows that they're not going to be able to make any decisions. So problems with partners, how to avoid the problems. Make sure you list it out explicitly in the operating agreement. Make sure payment terms are clear. Make sure you know when you're going to take a draw. How long after a project is it going to stay in the company. Make sure that all the initial contributions are clear, whether you're being money or equipment, and have a lawyer go over it. Also watch out for people that may not, high-level employees that may not have any skin in the game. They don't have an ownership interest, but do make a lot of decisions, and their skills could be easily transferred elsewhere. You want to make sure that you keep an eye on these employees. Have them sign some of these agreements that I just told you about. So some examples that I've taken. I was representing a multi-member LLC down in Florida about a decade ago, and there's a company who was making lots of money, and they came to a slow part and one of the members started expending more money on advertising and office space and wining and dining clients, and started depleting the company's reserves. Now, this wasn't explicitly listed out in the operating agreement, so he kind of had carte blanche on the decisions he can make. Well, what happened? He drew down the accounts and then told the other partners that he was going to invest another $100,000 into the company to keep it going, but he's going to need, he's going to need a majority, 51% of the company, so that he can make all the decisions unilaterally. What ended up happening? They kind of froze each other out. It went to litigation. They ended up splitting up and spending lots of money on attorneys. So that's a common situation that I want you to just be aware of. Really quickly, we'll go over the basics of contract law, offer, acceptance, counteroffers. What constitutes an offer? It's the willingness to enter an agreement on certain terms, an expression of that. Acceptance, that's accepting those terms. How is it communicated? It has to usually be, you'll find in your industry, it's going to be written contracts. Generally, for larger projects, you're not going to do anything verbal, but sometimes there are verbal. I'll go over those in a second. Counteroffers are actually a new offer. If it's a change in term, it's a denial of the initial offer and goes into a new offer. This happens many times during negotiation, and it's actually, believe it or not, it's one of the oldest laws around. There's a pretty detailed history that goes all the way back to the medieval ages in England about offer acceptance and counteroffers, but that's stuff we'll just go over quickly. Reliance and part performance. What if a contract isn't on paper and signed? Can there still be a contract? Yes, there are some verbal contracts. Think of smaller contracts. You're going to go do, you're going to change someone's bathroom. A lot of this stuff is done verbally if you're a smaller contractor. What if you talk to a guy on the phone and you have a small, like I said, you're going to go change a bathroom, and you're going to start work the next day, and you get a new contract that's far more lucrative, and you just say, hey, I'm going to make more money on this project, so I'm not going to go do the smaller project. Well, turns out that homeowner took time off from work to be there. He can hold you to that contract. If he relied on what you said you're going to do, he might be able to, take you to court and get some money for that. So obviously there's differences between ODOT contracts and small private jobs. The ODOT contracts will be explicitly listed out on paper, will be signed. They're going to be generally a lot more formal. Now, contract issues. The contract itself, generally there's form contracts in construction. It could be from an organization like AIA. You can have your own corporate lawyer do it. Most large organizations use their own contracts. And the most important part to think about is that you want the contract to favor you. If you use someone else's form contract, then the terms are going to favor them. You're going to want to make sure that if you do use one of these form contracts, make sure you read it, make sure you understand it. Understand your contract. I'm going to say that again. And if contracts come from upstream, make sure you read them and make sure they're fair to you. Quickly go over the termination rights. Usually they're spelt out. Look for them, see what would cause termination. Insolvency is bankruptcy. Usually contracts are terminated because they're finished. Look at the defaults. There's generally certain sections in there that will explain what are breaches. Most of the time it's because of delay, and it's sometimes easy to fix, and sometimes in the contract they'll give you a time limit on how to fix that. And you can't get out of contract just for convenience, like I mentioned before. If you have a contract and then all of a sudden the next day a more lucrative one comes in, you can't just terminate it because you got a better one, or if you found a cheaper price somewhere else. So with that, Victoria, quickly, could you put up poll question number 3?
It's up.
All right. Now I'm going to keep going. So there's several types of bonds. Everybody knows what these are. They're contracts, right? Does anybody say no? They actually are a contract. They're a contract between parties to ensure an outcome. Whether the outcome is payment or performance. It's a type of insurance. Performance bonds ensure that a contract will perform the work. Bid bonds guarantee bidders will obtain performance and payment. Payment bonds provide subcontractors and material providers assurance that they will get paid. Subs usually don't have to deal with bonds. Primes and generals do. Hopefully you will get to that point, but it is a big jump. How do you get bonded? Basically, you pledge your life. You pledge all of your assets, your capital. You're going to want to form a folder with all of your personal assets, all of your company assets, your history, your track record of construction projects, letters of recommendation, all this stuff. Put it in a folder, keep it around, update it. It's the stuff you're going to want to list. You're going to give to the bonding companies. The more detail you are, the less risk you are. Obviously, more assets you have. Yep.
67% said no, they've never obtained a surety bond before.
Well, hopefully that percentage will go up throughout your life as you get more experience. But it is a big jump to take because you are going to have to put your personal stuff on the line. Keep in mind that you do open yourself up for risk, and you're going to want to know that. It is risky, but obviously you're not going to get bigger projects if you don't do this. The more assets you have, obviously the higher amounts that you get bonded, and it's really the only way to get up into the higher levels. The price is a percentage of the project. The cost of the bond should be part of your bid package when you put it together. Not all insurance companies offer bonds. There's many companies out there, local, regional, national. Ask your primes and your general contractors. Ask around to see who they use. Something called Little Miller Acts. Those are requirements on what kind of projects need to be bonded. Always consult with an attorney or someone that a bond company that knows about requirements for bonds. This is because money flows from different pockets, sometimes federal, state, private. They all have different rules and regulations. So, check the bonding requirements for each project and know what you have to do beforehand. So notice commencement, this is the official date that a project has been started. It's the point from where deadlines are measured. You're gonna wanna make sure to write this date down and make sure that all your deadlines are in accordance with that date. It's given by the owner or the general contractor to everybody downstream, and it's required by Ohio law on all projects. They must be recorded. Where do you record them? In the county recorder's office is also the place where you can record liens and whatnot. There's required terms in there: legal description of the property, description of the property, name of the project owner, name of the real property owner, name of all the contractors, bond company, lenders, and the following statement below. I'm not going to read it. You can read it on your own. It just says that work's going to commence, and this is who's doing it, and this is information that you might be entitled to a lien if something doesn't happen. If you don't get one of these notices of commencement, ask for one. Keep it on file. It has important information that you'll need if you want to file a claim or begin a lien. Also understand sometimes work starts beforehand because there's specially fabricated items or there's a complex issue. There's something called an early start letter that governs the scope and terms of any work done before this notice of commencement's given. Notice of furnishing, that's on the back end. That's for the subs, everybody downstream. What this does is it secures lien rights for subcontractors. This is something you're going to want to do because it makes sure that you can get paid, if something happens. If they withhold payments, you're going to want to make sure that your rights are secured. And it lets everybody know upstream that you're engaged. This, again, is also required by Ohio law on public improvement projects. Not private, but public ones. So it just makes sure that you reserve your lien rights. And there's no real reason why you shouldn't do this every single time. Make sure you file within 21 days of your commencement. And all entities, again, downstream have to serve notice except the general contractor. Again, they have to have specific terms, names, dates, address, job, and some of these notices to make sure they're to be given in a manner consistent with regulations and the contract that you enter into. So going into construction contracts, there's going to be contract documents. There's going to be lots and lots of paperwork. Some contracts can be hundreds of pages long. Yes, again, understand, know your contracts. This is going to require you to read everything, even the small print. Make sure you know what you're getting into. That way, you're not going to get taken advantage of. That way, you understand the project. This consists of the owner-contractor agreement, the general conditions, the special or supplementary conditions for a construction project, other conditions. There may be restriction requirements or requirements to protect adjacent property. All the drawings prepared by the design professionals, specifications prepared by the design professionals, addenda, modifications. Tomorrow we'll be going over a construction contract and the general conditions and the special conditions. I'm sure you've seen them, but I just want to highlight some certain terms that you have to be aware of. Again, going back, understand your contract. You're going to want to know everything about the contract because it's your butt on the line. We're going to be going over the typical clauses, indemnity, workers' comp, DL issues, red flags, litigation concerns. So the contracts are the actual written ones. These are going to be all formalized. They're going to be separate from the bidding documents, bidding requirements, and drawings. Generally, they won't be vague. Generally, they'll be very specific and formalized. But if there is any vague issues, any vague terms, make sure that you understand why they're vague, or understand what the term is itself. You always want to, CYA, cover your butt, make sure you know everything. Generally, you get taken advantage of on situations that, you don't understand. When you don't understand something, this is where you're going to go down the wrong way. Again, we just went over these contract documents. We'll be going over them in detail tomorrow. Victoria, if you want to put the last poll question up, please.
Okay, I have two left. Yeah. So the very last one?
No, sorry, poll question number 4.
Okay.
We have you retained a lawyer in a construction issue. So when you're ready to hire an attorney on a specific issue, understand that there are many different types of lawyers. So some lawyers do multiple fields, some are in very specific areas. A litigator, or a trial attorney is what a litigator is a lawyer that specializes being in court. They know the civil procedure, they know the court the rules, they know the courtroom tactics, they know the judge, they know the judge's clerk. This is who you're going to want to represent you in litigation, but it's different than an attorney that may be going over your contract. They're definitely specialized. So, understand that not one lawyer can do, everything. It's kind of asking, a rock guy to go do some plumbing. Very specialized. The rules, the laws are different, and especially experience. Someone that's in the courtroom all the time probably doesn't do much transactional stuff. They're an expert at, picking juries, deposing people. So we want to know that beforehand.
Pat, 57% of the audience has not hired an attorney before on a construction issue.
Okay. Excellent. So yeah, just again, understand that there's different types of attorneys. You're going to want to make sure you know which one you hire. And I do both things. I do transactional work and I do litigation. But if I see a trial is going to go real big, I'm going to team up with some other lawyers and let them handle certain issues. So just understand that you're going to be, it's not just one lawyer that handles everything. You're going to have to contract with multiple attorneys if an issue gets big. Pre-contract issues, prevailing wages. So prevailing wages are set by generally the federal government, state governments, and county governments. So when you're estimating, you're going to want to make sure you have the correct wages. So the prevailing wages is not the same thing as union wages. It's not a shop out wage. They're different. The contractor gets to decide what they use. Just know that this is a decision that you can make. There's different ones you can put in. A lot of groups don't know that you can put in different wages, and it could really affect the way you do your estimation. For DBE and other contracts, just remember there's still a regular contract. Just because you have DBEs on it, don't think there's any special treatment or flexibility. If you don't abide by the rules, you may be removed. If a prime states that they intend to use DBE subs, they have to use those subs. They're going to be locked in. That's how the contracts are given. Make sure you have all the affirmations beforehand. Make sure you know all of them. It's good to have above the minimum percentages as well, because sometimes subs may fall off and the prime might dip below what the requirement was. And if you do dip below, and you may have to answer some questions. And if you go above what you're supposed to do, you show good causes why you weren't able to meet the requirement, and then your contract might be okay. Now again, remember, understand your contract. If you don't understand, get a lawyer. ODOT has guidance. They have tons of stuff on their website to help you understand what's in a contract. While some of them can be hundreds of pages long, you still need to understand it. Remember, is there a form contract or did your lawyer supply it? You want to make sure that the terms are favorable to you. We hear that ODOT receives a lot of calls from a lot of subs concerning the contracts. Well, remember, the primes sign the contracts with ODOT, not the subs. So the sub really can't get anything from ODOT. They can't negotiate with ODOT. They're locked in at those lower levels. Remember, subs can negotiate with the prime. So if you get into a certain contract with the prime, that you can negotiate, but you can't negotiate any terms that are between the prime and ODOT. And there will be some things that you're all locked in. And subs, you need to worry about your money. You need to, no one's looking out for you. You're looking out for yourself. The owners and the generals, all they care about is their money and whether a project is completed. So again, these are typical clauses we're going to go over tomorrow. Just to think about, before estimating and bidding, things that you're going to have to take into account. And while we can't control everything, we can, plan to be prepared, plan to give the best estimations. And this recent COVID-19 really shows us how little control we have over many things. I just want to make sure that you understand everything going forward and that you are best prepared to take care of it. Again, we'll go over these typical clauses tomorrow. Force majeure clause. This is kind of a funny one. It does actually say, usually in the event either party is unable to perform its obligations under the terms of this agreement because of acts of God, strikes, pandemics, equipment or transmission failure, or damage reasonably beyond its control, or other causes reasonably beyond its control, such party shall not be liable for damage to the other for any damage resulting from such failure to perform, otherwise from such causes. So, right now life is frozen. It actually does say pandemics in most of these clauses, which is kind of funny. So what a force majeure clause kind of freezes any claim. So if work can't get done right now because everybody has a stay-at-home order and you're not considered essential, this kind of clause protects you. Say, hey, I could not possibly perform, so you're not going to be in breach of contract and you're not going to be liable to that person because you couldn't perform. What's the best thing to do in cases like this? Make sure you communicate with, if you have subs, communicate with them. If you have your prime with the general contractor, just make sure you have a communication plan. Prompt Payment Act requires contractors to make payments to subcontractor on public or private construction projects. Even if a sub hasn't sent an invoice, if the general prime has been paid, they got to pay it on down. If a contractor receives application requests, they must pay within 10 calendar days. They can hold necessary amounts to resolve any disputes, but there are limits. Within 10 days of payment, subcontractor must make payments to lower tiered subcontractors and material suppliers. Under Ohio law, there is an 18% interest on amounts that are not paid. Is there a right to stop work if you're not paid? Well, that's not addressed under Ohio law. There's the law is kind of silent on that. Retainage for public contracts, for unit or lump sum price contract, 8% can be retained until 50% of the job is complete. After 50%, then 100% of the progress payments have to be released. The law is silent on the amount of retainage that can be withheld from subcontractors or material supplier. And after completion, after all claims, documentation, reports, as-built, after everything, not just when your job's done, the retainage can only be held for 30 days after that. On private contracts, 18% is only covered by a PPA. That's it. There's any further questions, that's it for today. I have about 1 minute left here. If you were wondering about what happened in the two examples I gave at the beginning of the day, the Vegas example with the bad concrete, what happened? Well, they had to rip out 3 floors 150 feet up. I can't remember exactly what the cost was, but it was significant, somewhere around 30 million, maybe a little bit more. Lots of people lost a lot of money. There were claims and lawsuits everywhere. And this all came from one guy who made $15 an hour who fell asleep one night. The New York example, unfortunately, 7 people died because of that incident. Adjacent buildings were damaged. There were claims and lawsuits everywhere as well. Loss of money, wrongful death lawsuits. the building did ultimately get finished, but at a great cost. So there's law issues everywhere throughout general business and construction. So you just want to make sure that you know beforehand what you're getting into. So with that, this is the end of day one. If you have any questions, please send them in. I look forward to seeing everybody tomorrow morning.
Pat, thank you so much. We really appreciate your time this morning. And if you haven't registered for tomorrow yet, please make sure you do so. We look forward to having you on part 2 of the webinar. And then when we end things here in a moment, please make sure you take the survey that's going to launch. Everyone have a great rest of your day. Take care.
Thank you, everybody. Thank you, Victoria.
Thanks.